Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara, Jurisprudence class. We are discussing another beautiful and important, very much discussed case law regarding the protection of life and liberty. And this is a classic case for right to know, or the principles of the natural justice. What is this case? Very famous case in 1978. Maneka Gandhi. Of course, we write it as Maneka Gandhi. Maneka Gandhi versus Union of India 1978. So this is another landmark case. So regarding the life and liberty, Article 21 of the Constitution of India. You all know she is very famous, Maneka Gandhi. Actually, she wanted to go abroad to other countries. So actually, for some official work, at the time she was working as a journalist, if I am correct, right? She applied for the passport. If you want to go to other country, number one, the first point is you have to get the passport, and the other country should give you the visa. Visa means visit, international stay, admission. So you have to get both things are there, then only you can reach the other country. Some countries are there to give on-board visa. That means even though you do not have visa, once you arrive at the destination like Malaysia, Malaysia and other places, you will get on-board visa, right? So she applied for the Indian passport as per the Indian Passport Act 1967. No doubt, she was issued the passport on 1/6/1976 during the emergency. 1/6/1976, she was issued the passport, right? But please remember here the important. On 2/7/1977, then she received a letter to surrender her passport. The regional passport officer asked her that her passport should be surrendered or it would be impounded under section 10 clause 3 subclause C of the Passport Act 1967. Of course, he has written it will be impounded in public interest, right? So she was asked to surrender the passport within 7 days of receipt of the notice. No doubt, she received the letter. Then she addressed another letter. She required the passport officer, please remember, to give reasons for the order, for the surrender. Why should I surrender the passport? What are the grounds to say that I have to surrender the passport? But the government of India or the passport officer refused, saying that it is in public interest. They are empowered to impound the passport. So her liberty is curtailed. Therefore, she filed a writ petition under Article 32. Article 32 of the Constitution of India, challenging the orders of the passport officer or the government officer. So this is what happened. So it is a case of life and liberty. That too, whether it is reasonable to say that the passport can be impounded in public interest. No doubt, the government or the passport officer is definitely having authority to seize, to impound the passport, provided if he has got information that it is being misused, it is going to be misused, or if there are any adverse reports on the integrity of the individual, or on the reports that the individual or passport holder has been involved in some criminal cases, and if she visits the other country, the the sovereignty and integrity of the country may be at jeopardy. But he has not given any reasons. What do the principles of natural justice say? Please remember, if at all you wanted to make any order, it should be a reasoned order, reasoned decision, speaking order. So, if the passport officer sent a letter to Madam Maneka Gandhi stating that, so you have violated so many conditions or information is like, therefore we are likely to impose your passport. That too, as per the second principle, they have to give a chance to her, to hear her audi alteram partem. So they have to take her explanation as to why the passport should not be impounded. But nothing of that's happened. They say that in public interest we want to seize your document. We don't want to tell the reasons for the same. Supreme Court said. Nothing doing. Even though, so please remember, the court held that Section 10 of the Passport Act, no doubt, it is 100% void because it confers vague and undefined power to the passport authority. So in the last class also, DP Chadda case also we discussed. Unbridled, unfettered powers, discretionary powers should not be there. Even though they are given, they should be properly utilized. అధికారం ఉంది కదా అని ఏది పడితే చేయటానికి లేదు. సో దేర్ షుడ్ బి సమ్ రీజన్డ్ డెసిషన్. ద పాస్పోర్ట్ అథారిటీ షుడ్ హ్యావ్ గివెన్ హర్ ఎ ఛాన్స్ టు హియర్ as to why the passport should not be impounded. They did not give any chance. So please remember, it is definitely violative of Article 21 of the Constitution of India as well as Article 14 of the Constitution of India also. Therefore, this case is considered as a landmark case for the interpretation of life and personal liberty as envisaged in Article 21 of the Constitution of India. So please remember. So when this case saw a high degree of judicial activism. Judicial review. So the court has stepped out of his and confirmed that this is a case where the principles of natural justice are not followed. So unbridled powers should not be there. So please remember, actually this case is also called as a golden triangle case because Article 14, Article 19 and Article 21. They have been interlinked and they have discussed together. So therefore, it was highly appreciated by one and all. So a right to travel, the important point is a right to travel abroad is actually covered under Article 21 of the Constitution of India or not. So procedure prescribed by law. So which strips or which curtails the personal liberty under Article 21. So is definitely arbitrary or not? Is it against to the principles of natural justice or not? So Supreme Court discussed so many cases like ADM Jabalpur versus Shivlan, Sevkan Shukla and all things, and they have clearly stated that the reasons should be given. When once the reasons are not given, then definitely it is irrational, unreasonable. Ultimately, the passport officer could not be avail the chance of seizing the passport of Maneka Gandhi. Of course, there are some political implications. Let us not bother. Only as far law is concerned, this is a good case for the test of reasonability. So దీంట్లో ఆవిడ పాస్పోర్ట్ సీజ్ చేస్తామని చెప్పి నోటీస్ ఇచ్చారు. ఆవిడ ఏమిటయ్యా కారణం అని అడిగింది. చెప్పలా, కారణం చెప్పక్కర్లేదు, పబ్లిక్ ఇంట్రెస్ట్. కానీ సుప్రీంకోర్టు ఒప్పుకోలా. మీరు కారణం చెప్పకుండా ఎలా సీజ్ చేస్తారు? కారణం చెప్పి సీజ్ చేయండి. ఎందుకంటే సెక్షన్ 10 గివ్స్ ఎనార్మస్ పవర్స్ టు ది, విపరీతం పవర్స్ ఉంటాయి. కానీ ప్రిన్సిపల్స్ ఆఫ్ న్యాచురల్ జస్టిస్ ఫాలో కావాలి. అలాగే యూ కెనాట్ కర్టైల్ ది లిబర్టీ ఆఫ్ ఎ పర్సన్ టు ట్రావెల్ అబ్రాడ్. సో ఇది కూడా దీంట్లో కవర్ అవుతుంది. ఏడిఎం జబల్పూర్ కేసు కూడా బాగా దీంట్లో డిస్కస్ చేశారు. వన్ ఆఫ్ ది బెస్ట్ ల్యాండ్ మార్క్ కేసెస్. ప్లీజ్ రిమెంబర్, దీన్ని గోల్డెన్ ట్రయాంగిల్ కేసు కూడా అంటారు. ఒక పక్క 14, ఒక పక్క 19, ఒక పక్క 21, 3 డిస్కస్ చేశారు కదా. సో విత్ దిస్ ఐఎమ్ కంక్లూడింగ్. థ్యాంక్ యూ వెరీ మచ్.